you don't mind that I'm going to stand up. So I've made my career out of the assertion that there's no such thing as a silly constitutional argument. But Mr. Rivkin, I'm afraid, is making me rethink my career choice. This is an argument that is truly silly. Now, because I'm not eager to give up my career, I want to qualify that assertion in one way. The plausibility of all constitutional argument turns on the social and political setting in which the argument is made. And there are constitutional entrepreneurs, people like Thurgood Marshall or John Yoo come to mind, who try to change the social and political setting. John Yoo might be thought of as the Thurgood Marshall of torture. And when these entrepreneurs succeed, as Thurgood Marshall did, they become historical heroes. When they fail, as John Yoo appears to have, they're investigated by the Justice Department. So one might think of Mr. Rivkin as a constitutional entrepreneur in the Marshall-Yoo tradition. I'm going to come back to that possibility at the end of my remarks, but for now, at least in the current political and social setting, I think Mr. Rivkin's argument is silly. Now, why is that? Well, the reason is that for at least 3/4 of a century, the Supreme Court has consistently held that when Congress regulates a national market, the regulation is permissible under the Commerce Clause, even when individual transactions within that market are local in character. Moreover, the court has also made clear that Congress can regulate economic activity that is purely local when it has an impact on national markets. So famously, the court held that Congress can regulate the decision of a farmer to grow wheat in his backyard for his own consumption because that decision had an effect on the national market in wheat. Or Congress can regulate the decision of a local restaurant not to serve local black customers because that decision, by the way, a decision not to act, that is to say not to serve somebody, has an impact on the interstate movement of food. These are well-established precedents. They're not about to be overruled. Now, there's unquestionably an interstate market in healthcare. And the failure of young and healthy individuals to purchase health insurance has an impact on that market, much as the failure to serve African Americans has an impact on the market in processed food, and the failure of farmers to buy interstate wheat has an impact on the wheat market. George Akerlof won a Nobel Prize for showing that what he called adverse selection means that insurance markets left to their own devices malfunction. Simply stated, the problem is that insurance is expensive, so healthy people who don't need it opt out. That means that the pool of insured are mostly sick, which makes insurance more expensive, and the added expense means that more people opt out, and so on. The market never equilibrates, and the net effect is that the risk sharing that's at the heart of health insurance unravels. I think that most people who've studied the matter believe that Akerlof is correct and that insurance markets therefore must be regulated. But for present purposes, it doesn't matter whether Akerlof is actually right or not. As conservative constitutionalists used to understand before they realized it served their interests to ignore the point, policy questions are for our elected officials, not for judges. And if a court were to upset this policy judgment, and with it 75 years of unbroken precedent, it would be the most activist court in our recent history. This current Supreme Court is just not going to make that mistake. Whatever else one thinks of the current justices, they're not stupid. First, on the Supreme Court and a prediction about what's going to happen, Mr. Rivkin may be right.